Wait, please, Lord. We have circulated a letter in respect of item number 14, Milord.
Yes.
Now, this is a matter, Milord, where, Milord, after filing of the writ petition, government has taken some steps. As a matter of fact, our cases are under consideration.
Consideration for what?
They have consideration for processing our case for pension prior to 2005.
Okay.
In that view of the matter, Lordship can call this matter after 2 months, Milord.
Mr. After 8 weeks, at the request of Mr. Senior Counsel. Mr. Senior Counsel, Mr. K. N. Chaudhary has submitted that the government is under consideration for granting relief to the appellants. Therefore, matter may be adjourned list after 8 weeks.
Deep your right.
Adjournment request from item number 1 to 4. From item number 5 to 11. From item number 12 to 22, adjournment request.
Item number 22, Malad.
22.
22. Malad, I am for the Malad petition. I left the concerned case record. So
You have left the
I left the case record. Malad, somehow Malad pick up some other case. So I am paying for an account. It's a Malad, difficult situation without that brief.
it's a matter of dual pension. Dual pension matter.
Malad. A day accommodation, Malad.
List after a week. May I the request of the learning council for the petitioner list after a week? Yes.
May I say that the date may be
Item number 22.
not it.
Date 2 weeks बाद में ask the court master, they will give it.
May it pleases your lordship. Lordship, I beg to mention item number 15. Lordship, I'm appearing for the respondent in this case. If the matter may be adjourned for the day, your lordship.
15. You are for?
I'm for the respondent. Consent has been taken, your lordship.
The staff list in the month of August, at the request of and consent of the respondent. List this matter. Yeah, the adjournment request is made on behalf of the consent for the respondent. Who is for the other side?
So FCI, your lordship.
You have taken consent
Yes, your lordship.
with the consent of the other side. List after list in the month of August.
May I please, Lordship? That's why I beg to mention item number 16.
Yeah,
Lordship, in this case, I am filing an additional affidavit, Lordship. I have taken consent of the other side also. It may be taken up next week.
you are for the Union of India?
Yes,
No,
Lordship. Yes,
you,
sir.
you are for the Union of India?
Union of India, Lordship.
The request of the council, you are for, who is for the other side?
I am for item number 7, your lordship.
Your lordship, I am for the other.
Do you have any objection?
Your lordship?
Do you have any objection to the adjournment?
No, Your lordship.
Request of the council for the list petitioner list in the month of, no objection from the other side, list in the month of August. Yes,
Obliged, Lordship.
Your lordship, item number 7 was called for. I am for the petitioner. Request, no, sorry, your lordship.
So, my lord,
item.
item number 28. Item number 28.
Yeah,
We have received the affidavit in opposition to prepare the counter affidavit. I seek some time, my lord.
item number 28.
28.
You are for the
I am for the applicant, D.N. Sharma,
petitioner,
petitioner.
Niranjan Das, Dr. Niranjan Das.
Yes, Mr.
You are filing when?
My lord,
By what time you will file?
by 2 weeks.
Okay, then council, so place for an adjournment list after 2 weeks.
Lordship, I'm for the UPSC respondent number 3.
Other side with no objection from the other side, list up.
Wait, please, Lordship. I beg to mention item number 24, madam.
Yeah.
Today I am filing our affidavit in opposition in this matter, madam.
3-4. Legal and council appearing for the respondent. They submitted that. Oh, you have informed the other
Yes,
side?
yes, madam. I have informed all.
They submitted that the affidavit in opposition would be filed during the course of the day. List after 3 weeks.
Obliged, Lordship.
Any other request? Daily list for orders item 1.
Here, both the appellant and the private respondent who were vying for the post of principal, they have both retired. The private respondent has expired also. Nothing remains here, my lord. The in charge is now running the school.
The respondent number one is not served till date.
My
It is
lord,
expired.
he is expired on 6/02/2020. After
Oh.
retirement, he has expired, my lord.
Then,
Appellant to retire, Lordship.
Appellant also retired from service, my lord.
so there is nothing remaining
Nothing
in this
left.
petition. Nikhil and council applying for the parties have submitted that since the appellant as well as the private respondent now deceased has already been retired from the services. There is nothing left for adjudication in the matter. What was the matter about?
My lord, the selection of a regular headmaster, the private respondent.
So there nothing is left to adjudicate in the matter, hence the writ appeal is closed. IA number so and so is also disposed.
I'm obliged.
Obliged.
Item number 2.
In this matter, Lordship, as per the direction of this honorable court, Lordship, we have filed one consolidated report, Lordship, indicating the infirmity, Lordship. And in response, Lordship, the state has filed their affidavit, Lordship. Perhaps the affidavit filed the Arunachal Pradesh, Lordship, that is not in the record, Lordship.
Arunachal Pradesh already filed, I think.
Filed it on Tuesday, Lord.
Tuesday.
And in the affidavit, Lordship, they assured that they will working on, they are working on it, Lordship. Lordship, may pass necessary order, Lord. In the affidavit, Lordship, they have stated, Lordship.
In Arunachal affidavit,
Yes. They have filed, Lordship.
you are in
Yes.
receipt of that?
Yes, we have received, Lordship. The major issue is regarding Lordship, nowadays, Lordship, overcrowding, Lordship. And if your Lordship may kindly come to the order dated 15/12/2022, Lordship,
Yes.
there is a direction. And we have also indicated in our consolidated report also. Lordship may kindly come to para 7, Lordship, State of Assam regarding. The State of Assam with the aid of Assam,
Yes,
Lordship. I'm sorry. Modification release 15/12 para 7 already I have both report 15/12 15/12 না সেইটো already আমি কথা report দিছি এইটাই 15/12/22 কথা কৈছে para 7 সেইটো সেইটো
Release para 15-12 report, it can members get a report. Not from be released to. Management release to member category. Already even acceptance file को even manually required to release कोई नहीं तो पूरा होगा क्या पूरा किया करता है बाइट पूरा बात को बाइट इनका तो मुझे ऊपर से हाँ तो जैसे जेल में member secretary है जो हम दूसरे का secretary रिक्वेस्ट करेंगे
Test affidavits. Test affidavits. Like that. Paper. Yes, yeah. 2020. MP. बिल्कुल नहीं। Arunachal, you have filed on Tuesday. In respect of this state of Mizoram, you have pointed out certain deficiencies.
Yes, regarding main issue is overcrowding, Lordship.
In the respect of state of Mizoram.
Yes, Lordship. The main issue is
You
overcrowding.
filed any reply in response to that, the deficiencies, when you have filed?
They have stated that
9/5.
in para 3, Lordship, they have stated regarding overcrowding.
Your copy of that response?
But I have got
Do you have an extra copy? Give it.
one copy of.
Okay. This petition, this suo motu petition is registered pursuant to the directions issued by the Honorable Supreme Court in WPC number 406 oblique 2000, pursuant to the direction given by the Honorable Supreme Court on 8 May 2018 in WPC number 406 oblique 2013 in bracket Katina re inhuman conditions in 1382 prisons. The Honorable Supreme Court has directed to register a suo motu writ petition on the issues of overcrowding in prisons, vacancies in prison staff, and women prisoners, and condition of women prisoners and their children. After registration of the suo motu writ petition or this suo motu writ petition, this court has passed several directions from time to time seeking reports from the state and the jail authorities of state of Assam, Mizoram, Nagaland, and Arunachal from time to time. Several directions were also given by this court, taking into consideration the reports submitted by the all four states. However, on 15/12/2022, after considering the various reports filed on behalf of the state of Assam, Nagaland, Mizoram, and Arunachal Pradesh, this court has directed each of the state to constitute a committee and to constitute a committee in each of the states consisting of police officers, prison authorities, and member secretary of the Nagaland, of each of the state legal services authority. The order dated 15/12/2022 is reproduced here under. 15/12/2022. Reproduced. Pursuant to those directions, committees have been constituted in each states, and they have also visited the prisons of the state of Assam, Mizoram, Nagaland, and Arunachal Pradesh, and submitted a comprehensive report for each of the states. The inspection committee has highlighted that the situation prevailing in the states of Assam, Nagaland, Mizoram, and Arunachal Pradesh are not satisfactory, and they have also suggested certain they have also recommended certain suggestions. Taking into consideration the report of the committee, this court on 20th of December 2024 directed each of the states to file affidavit addressing all the issues highlighted by the committee in its inspection report. Pursuant to the said direction, the state of Assam, Mizoram, Nagaland, and Arunachal Pradesh have filed their responses. However, the learned amicus curiae has pointed out certain deficiencies in the reports submitted by the aforesaid four states. This court on 10/3/2025 has directed the council for the state of Assam, Mizoram, Nagaland, and Arunachal Pradesh to file their response to the deficiencies pointed out by the learned amicus curiae in its report dated 7/4/2025. Pursuant to that, each of the states has submitted their response. The state of Assam in its response the response is submitted, the response submitted by the response of the state of Assam submitted through affidavit of the Inspector General, Prison, Assam Prison Headquarters, Kanapada, has The relevant portion of the affidavit filed on behalf of the state of Assam regarding the measures taken for curing the deficiencies pointed out by the Ranid Amicus Curie are as under 985 page, para number 3 to 4. 3 and 4. इसमें देखो ऐसा है जो 3 है ना, this is the chart. You quote of this chart. This 2. ये यहाँ पे 4 तक 4 तक ये बाकी फोन नंबर वगैरह ये नहीं. Similarly, affidavit dated करते हैं ना 17th May 2025 है. Similarly, the state of Nagaland has submitted its response to affidavit dated 16th May 2025. The relevant portion of the said affidavit is reads as under. ये पेज नंबर 978 से पैरा नंबर 2. Don't check these connections. Connection ये पैरा नंबर 3 जो भी है पैरा नंबर 3 खोल. Response is also filed on behalf of the state of Nagaland. This was of state of Nagaland तो अभी बताया था ना 978. State of Mizoram. Page number 973 said the relevant portion of the said affidavit is reproduced here under para number 2, page 97, para number 2 to 9. The response filed on behalf of the state of Arunachal Pradesh on 20th of May 2025 is also reproduced here under para number 2 to 5. Para number 2. Having considered the responses filed on behalf of the learned counsel for the learned counsel for the amicus curie has submitted that the respective state governments have filed their response in respect of the deficiencies pointed out in the report that itself. So a direction be issued to the state of Assam, Mizoram, Nagaland, and Arunachal Pradesh to take corrective measures expeditiously to cure that deficiencies. So, having gone through the latest affidavit filed on behalf of the state of on behalf of the above referred 4 states, we are of the view that this fair petition is required to be disposed of with the direction to all the states to carry out to implement to act in effective manner and to act expeditiously in effective manner to cure the deficiencies pointed out by the learned Amicus Curie in its report dated 7/4/2025, in accordance with the response filed by each of the states. The said deficiency be cured as per the measures adopted by the states within a period of 6 months from today, to stop the respective the state legal services authorities today. The state government from today, the state governments are obliged to inform the member secretary of the state legal services authority of each states regarding a progress carried out in the regarding the progress in respect of the measures adopted by each of the states to cure the deficiencies in the prisons in every 3 months from today. The member secretaries of the state legal services authorities of each of the state shall verify regarding the compliance, and if find that the compliance has not been made in effective manner or has not been fulfilled, then they may inform that they can approach, that they will approach this court by filing appropriate proceedings. With these observations, this PL petition is closed.
One small prayer, Lordship. Lordship may have offender problem revocation, Lordship. If it is required, Lordship.
So only member secretary, we have granted liberty to member secretary of each of the state legal services authority to inform this court about any deficiency.
Lordship. Deeply obliged.
Item 3.
No, as per direction of this law, we publish a notification in the newspaper, Lordship, 2 newspapers.
Where is that?
Lordship, we filed affidavit in the month of December, but I didn't find the affidavit in the record, Lordship. But I will verify and, but it is, my,
But that affidavit in December you have filed, but it is not there.
it is already filed, but it is probably, unfortunately, it is not found in the record, Lord. I may make
Legal
inquiry in.
counsel for the appellant has submitted that the paper for petition has already been completed. And in respect of the same, he has also filed an reply, an affidavit. However, the said affidavit is not on record. Then it concept of the appellant takes some time to either to take some time to complete his instructions. This after 2 weeks. Make a fresh affidavit, fresh affidavit if you have already filed.
Lordship.
Item 4.
May please, your lordship, this matter may be listed for admission. Your lordship.
This
It is their own case, one of the, all the directions, positive directions have already been complied with. It's only a liberty that was granted to us to approach the civil court in respect of one portion of the area salary that was claimed in the writ petition. That is the only issue that remains. I don't think how the writ appeal has been kept alive.
No, that but the court has already stated that
Only the last paragraph, paragraph 24 was stayed, and that also they have, before that order was passed, they had already complied with it.
that is the stay order is dated.
20, 17/8/21.
17th,
Oh, no, that is the judgment.
8/8/22. 22. Even that portion was already complied with.
Lordship, I'm not in this case, your lordship. If your lordship pleases me, pick up.
Just a minute. Let us see. 8/8/22.
8th of August 2022.
With the order.
It's in the main writ petition.
Main petition. Meanwhile, direction issued in paragraph number 24, the ensuing judgment that shall remain state. What are those directions?
My lord, there was a cost imposed of 30,000.
That's all.
The other directions are at paragraph 22, my lord. Those directions have already been complied with. And it is their own case. They perhaps, for some reason, they failed to inform this honorable court at the time of this interim order that they had already paid the cost also.
Prior to passing of this
My-
cost also.
And all the other directions, positive directions, if your lordship sees, the main directions are at para 22A and B. These are long since complied with. It is only para D where liberty was granted to me to approach the civil court.
For what?
For I had claimed arrears of salary with effect from 2015 to
Have you
2009.
approached the court? Have you approached the?
Yes, ma'am. And what they are doing is, whenever the matter comes up before the civil court, they simply say that there is a writ appeal pending, and that's how the matter has got stuck there. Otherwise, nothing remains in this writ appeal.
After some time, your lordship.
After some time,
Yes, your lordship.
where is he?
Lordship is on legs before another court.
Okay.
In that case,
For
madam,
the
can
timing,
can it
for
be
the timing.
next week, madam?
For the time being,
Item number 5.
yes, Mr. Majumdar, you were supposed to, in the last occasion, you informed that the government is in contemplation of issuing a memorandum.
Yes, madam. Please. The second bullet, lordship.
This is all.
This is of 22/5/2025. My instruction is the 22/5/2025.
Lordship, I have a small issue, Lordship. Yesterday, we tried the online portal. Can I just share this with Lordship? How this portal is actually working, Lordship? And Lordship, they have completely diverted from the issue by issuing this letter. Lordship, I'll just take, this is nothing. Lordship, the first issue is when we opened the portal yesterday, we tried because we had 3-4 children who from Kamrup district who were trying to register themselves online for the admission, Lordship. Lordship will kindly come to the first image. The first image shows that there are only 2 tabs. One is for the students to register and the other is for the schools. And the second image, Lordship, is to upload the documents and the it's basically to upload the documents which are required for 12-1C admission. The challenge comes at image 3, if Lordship comes to image 3. What happens here is, Lordship, if a student has registered himself in Kamrup district, the drop-down schools, and there is not a single school from Kamrup who has registered themselves with this portal, Lordship. What happens is, if Lordship can read it, it's very small, but even I have some difficulty, I'll read it. Our student was from Kamrup. He had sought admission in class 1, Lordship. And the schools which are here, they are from Jala, Nolbari, Nagaon, but nothing from Kamrup. So the selection says select school and below it says not applicable.
Not applicable what?
Not applicable because none of the schools from Kamrup district has registered themselves with the portal. So what we could, in fact, every 10 days, 15 days, we are going online to check the portal, Lordship. Until recently, there were no schools. Only yesterday, we found 9 schools registered with the portal. Now, the thing is, Lordship, what I think is they have placed the onus on the schools to register themselves. Until and unless, Lordship, there is a mandate or systematic inclusion, these schools will never register and the children will never get the benefit of 12-1C. They have a portal in place which is completely non-effective, Lordship. And now with this new letter which my friend has just given, the first line itself says vernacular medium unaided. 12-1C is all about unaided minority schools. There is nothing called vernacular in that, Lordship. They have completely changed the language, completely changed the whole fraction of the 12-1C, and they've come up with a new thing, Lordship. Right from the beginning, Lordship, our prayer was.
You place this document on record by way of affidavit signed and counted to. What's the problem?
Lordship, I have just one prayer. The mandate says, then OM says that the online portal, the schools would register themselves, the students would come in and they would say, why is it being done? Just one thing done, other things not done. Now here also they say it is, I have just gone and brushed up this lordship. Like it is for the schools to come. It's already
There's
there.
no mandate on the part of the government that you should register yourself, otherwise you'll face these consequences.
And
You-
lordship,
they-
if child is registering himself in Kamrup, where will he
Madam,
go?
that's why only we are asking that. To place this, whatever you are now, you introduce this mechanism, to place it on record through affidavit and you fight up this counter to that. Then we'll consider whether it is a compliance of 12(1)(c) or not.
We'll do
Not,
that,
then we
lordship.
pass necessity order.
We'll file an affidavit on the letter which we received today, lordship.
Let them
Yes.
sign their affidavit.
Okay.
I'll bring it.
Let them.
So lordship will give us a short date, lordship, because this matter
We'll-
is
we'll-
pending for quite a while.
Wait for, please listen for an order. Yeah, Mr. Majumdar. The training concept for the education department has submitted that the state government has already issued directions for registration of the schools of the state of Assam in the portal. On the online portal in compliance of section 12(1)(c) of the Right to Education Act 2009. Mr. Majumdar takes 10 days time to file the place on record the instructions, public directions issued by the state government for the compliance of section 12(1)(c) of the Right to Education Act 2009 through affidavit. The affidavit be filed regarding the compliance of section 12(1)(c) of the Right to Education Act 2009 within a period of 10 days, while sending a copy of the same in advance to the counsel for the PIL petitioner. Full stop. The PIL petitioner is at liberty to file response to the said affidavit within next 10 days,
1 week, lordship.
within next 1 week. Let's start. 20 days. List on so and so.
I'm obliged.
Obliged, lordship.
18 June. Item 6.
My lord, here is a case where lordship has on last occasion pointed out about the maintainability. And lordship, so far the respondent number 1 and 4 are concerned.
Yeah.
This is awaited. And second issue, the lordship has pointed out last occasion about the maintainability of this rate appeal in the context that the order which has been passed by the learned signature passed on to the labor code, whether it is maintainable. Lordship, in this case, my lord, I have found 2 or 3 judgments. Now, so far 2017 judgment is concerned Ramkrishna Toji's case, my lord.
Not
Let-
Ramakrishna Fauji.
My lord, 2017, 5
Ramakrishna
SCC.
Fauji in relation to criminal matter.
My lord, I'm just referring that afterward, my lord, what happened, the Chhattisgarh High Court dealt with the issue that this same issue was dealt with. Initially, it was referred to the division, larger bench, my lord, finally.
It is not only one matter. There are so many other matters.
Yes. Rate appeal 152, rate appeal 152/24. Series of matters has been paid.
There are series of matters
Yes,
there. We have also appointed some amicus curiae in that.
Yes, sir.
My lord,
List along with this number there.
152/24. Rate appeal.
160.
Along with.
One
So
fifty.
in the meantime, the concept for the appellant may take steps for service of notice upon the respondent number
1 and 4.
1 and 4 through registered AD and so and so. Requisites registered AD and trustee. Requisites be filed within a period of 1 week on filing of the same. Let notice.
My lord, that's the my lord possible, my lord, because that
Okay, registered AD.
registered it.
On the filing of the same, let notices be issued to the respondent of our purchase code to register date, return a 3 weeks thereafter.
Deeply.
Item 7.
Yes, sir. On 10th of February,
Lordship, the matter is now pending at the directorate level at Delhi, Lordship. So I have been requested to ask for 1 month time, Lordship. The director of pension, Lordship.
Nikhil and counsel appearing for the contender that submitted that the matter has already been, the recommendation for implementation of the order dated 6/2/2023 is already been sent to the
Office of the
postal office of the Directorate Dak Bhavan, Sansad Marg, New Delhi, by the Office of the Chief Postmaster General, Assam Circle, by letter dated
Lordship, 7th May, Lordship.
7th of May 2025. The counsel appearing for the contender has submitted that 4 weeks time may be granted to comply the order passed by this court in dated order dated 6/2/2023 passed by this court in writ petition number 4045 of 2019 and other connected writ petition. Rest after 4 weeks.
Deeply obliged.
Item 8.
Yeah, but I saw the copy of the IA to the respondent on 29th through Dusty Manu. Today I am filing the affidavit on Dusty affidavit.
Nikhil and counsel appearing for the state has submitted that affidavit regarding the service upon the regarding the justice service
service.
upon the respondent number 1 would be filed during the course of the day. List after 10 days.
Obliged.
Item 9.
So no steps have been taken.
Lordship, I have taken yesterday, Lordship.
What steps?
Lordship,
As per the office report, no steps have been taken by the petitioners for service upon the respondent upon the
sole respondent.
sole respondent. Learned counsel has submitted that the steps have already been taken
Yes,
for
I did.
service of respondent on 22nd of May,
Lordship.
22nd of May 2024, 25. Stop. Await return of notice of sole respondent for 4 more weeks.
Item 10.
Lordship, with due permission, Lordship, I beg to withdraw the case, I with a liberty face. This honorable court already observed by the
Which sir? Item number?
10. I civil that case, your Lordship, in last occasion, this honorable court pointed the officer in charge to be attested signature, whereby I have been signed. So in the same order have already been observed by this honorable court. I will be allowed to withdraw the case with a fresh liberty. That
The-
case, sister case.
IA or this?
I.
Nikhil and counsel for the petitioner, applicant has submitted that since the IA number 583 of 2025 is not accompanied by the affidavit of the officer in charge, he wants to withdraw this IA with liberty to file fresh one. So permission is granted. The interlocutory application, IN number so and so is then dismissed as withdrawn with liberty as prayed for.
Deep level.
Item 11.
Six hundred and 17 days.
My lord.
Why?
My lord, what has happened, my lord, in the original order of the Honorable Learned Single Judge, my lord, there were 3 writ petitions were filed, my lord. And in that 3 writ petitions, my lord, some relief had been provided to the appellant. Now, my lord, what has happened? The private respondent's appointment, although it had been held to be illegal, my lord, but that has not been set aside, and the part of provincialization was also under challenge in a writ petition, my lord, that has not been.
Your
My lord.
termination or whatever it may be, that has been cancelled and you were relegated to the tribunal.
No, my lord, that part is already under challenge in the first round of writ appeal. My lordship is examining, my lord. That is pending, my lord.
Notice written
My lord.
10 weeks.
Obliged.
Pass over meter 4. May it please, Your Honor. Here issue only remains lordship with regard to B lordship. Kindly peruse page 241 lordship.
What is this? D?
Lordship,
That liberty granted to approach the civil court.
You are agreed by that.
lordship only there, but
Why?
other part of our lordship.
Why?
Lordship, may I submit one thing, lordship? Lordship, let this matter may fixed for admission, lordship.
Huh?
Let this matter be
But
fixed for admission.
you show us why. What's the
Lordship.
problem in
Since as
The-
per order dated 25 to 2025, lordship. this
2000?
matter-
That is, that is a part which has gone in their favor.
Yes, this is the para D, the
The court is inclined to relegate the petitioner to the civil court to hesitate his money claim against salary from so and so. At the time, he was not working, lordship. Accordingly, it is provided that in the event the petitioner files a suit within an outer limit of 6 weeks from the date of this order, the petitioner would be entitled to claim the benefit of the provisions of Section 14 of the Limitation Act 1963 for hesitating his claim before this court in WPC so and so. Accordingly, in respect of claims for current salary are made in prayer D, B of so and so and prayer C of so and so, it is ordered accordingly. So this much, lordship.
so how you are agreed by this?
Lordship, let the matter be fixed for
Hey,
admission.
you just show us.
No, lordship, basically we are agreed by this point because at that time, lordship, he was under suspension, lordship.
So you contest this, whatever the civil proceedings, he is not entitled for that. Learned Single Judge has not given any finding regarding that he is entitled.
That is pending before.
That is
Before
pending.
that, lordship.
So before that court where the suit is pending,
Lord.
you raise your objection. He is not entitled because he was not working.
Lordship, now question arises whether the honorable single judge is entitled to give this relief to the petitioner or not.
Which relief? There is not relief. Only liberty is granted.
Liberty is granted. Whether the honorable single judge is
Why
entitled to give the
Why
liberty.
not, sir?
Lordship.
What's wrong in that, sir? If they simply said, "Okay, we are not giving this relief and you are free to approach the this civil court for their money claim,"
Lordship.
that is the remedy available to them.
Lordship. Lordship, I will try to satisfy you. Let the
Sir,
matter-
what is the satisfaction? Please let us.
Lordship.
Sir, be rational.
Lordship.
What's the problem in that, sir?
Lordship.
We would have understand that you are agreed by this rupees 30,000 which you have already deposited.
Already deposited. After
Then-
passing of this.
And all the other leaves you have already been
Lordship.
granted. Then what remains, sir?
Lordship, kindly accommodate for one day, Lordship.
Sir, for what?
Lordship, I will try to satisfy you, Lordship.
Sir,
Because today,
sir,
since
you
the
are
matter is
here,
fixed for order, Lordship.
you please satisfy us.
Lordship,
What's the, we don't find anything. We have simply said, if he is not entitled, the court has not said, the civil court shall pass a money dictum. It has not been said. They have simply said, inclined to relegate the petitioner to civil court to agitate.
Lordship.
He will agitate, you will also agitate.
Lordship, can the matter fixed for admission on another level? I will try to satisfy, Lordship. I will try, Lordship. Since the matter is
Please,
fixed for order,
I
Lordship.
understand.
Only one day, Lordship. Only one day, accommodate.
Okay. This court, by the impugned order, sir, simply because for the sake of this, you want to argue, then it's okay. Otherwise, there is nothing in that.
Lordship, I will
So
try.
try to understand what is that, why to multiply these proceedings? When there is nothing in this matter, you already complied with. Please try to understand, sir.
Only one.
Sir, for what?
Lordship, because Lordship, today I am not prepared. Lordship.
Sir, you prepare, read your grounds in the appeal.
Lordship.
We'll look into it. What are your
It
grounds?
can be on third Lordship. Just one day.
Okay, we'll go through it. Just for the sake of your satisfaction, please, for one day, for what? What are your grounds in the appeal? Read your grounds.
Lordship, it starts from page 14, Lordship.
Read.
For that is a settled proposition of law that while exercising power under Article 226 of the Constitution of India, this High Court should not act as an appellate authority. It is its jurisdiction is circumscribed by limits of judicial review to correct errors of law or procedural laws leading to manifest injustice or violation of principles of natural justice.
Right.
2. For that the judicial review in the matter of disciplinary proceeding is permissible with respect to decision-making process and not against the decision itself. But the Honorable Single Judge, while passing the impugned judgment ordered at 17/8/21, had acted against the decision of the appellate in issuing so-called notice by adjudicating disputed facts. That is over. 3. For that the opposite party number 1 had filed both the writ petition being so-and-so against the impugned so-called notice dated and the letter dated instead of participating in the inquiry, and as such the writ petition is premature and not maintainable on fact and in law, and is a settled proposition of law that ordinary law writ lies against a so-called notice unless same is without authority of law. 4. For that the purpose of issuing so-called notice is to afford opportunity of hearing to the employee, and once cause is shown, it is open to the authority to consider the matter in the light of the facts and submissions placed by the employee, and only thereafter a final decision in the matter would be taken as to whether a disciplinary proceeding could be drawn up against the erring officer or not. In case the disciplinary proceeding is drawn up, the employee will be granted opportunity as contemplated by law. 5. For the impugned common judgment order dated passed by the Honorable Single Judge in WPC number 3264 of 2017 is not sustainable in law. As such, the said judgment order dated 17/8/2020 so far relates to relief claim in WPC number 3264 of 2017 is liable to be interpreted.
There is the argument regarding the point number D. Not a single argument.
One, Lord.
One.
Lord.
Yes. You simply said limits of the judicial review, they should not interfere in the discipline proceedings.
Lord.
What about the argument regarding that which you are saying that I want to argue on this point? Where is that, sir? Where is the pleadings of that?
Before coming to the finding in what the Honorable Single Judge has pointed out in point number D, Lord.
Sir, please, you have complied with the order. Before filing the appeal, you have complied with the order.
But D part is only remaining.
Sir, D part is nothing. D part, they have simply granted them liberty. Yes, additional that limitation would be considered. The case of the condonation or limitation would be considered in light of section 14. That was the only direction. Please. Just for the sake of adjournment, please don't ask for this.
Your Lordship, may I put an observation in them.
What?
With regard,
what observation?
With regard to this direction number D.
Direction number D, yes, okay. Okay. This writ appeal is tried on behalf of the respondents being agreed with it. There is one appeal or
one appeal.
One appeal. This writ appeal is filed by appellants being agreed with the judgment dated 17/8/2020 passed by the London Single Judge in the petition number 3264/2017. Thereby, the London Single Judge has allowed the writ petition filed on behalf of the private respondent number what? You are respondent number 1 or
1?
Respondent number 1 and has granted it and issued the following. directions. Para number 22 say. Directions, full stop. It is submitted by the learned counsel for the respondent that the directions issued by the learned single judge in para number A, B, and A, B, C, E
As well as 24.
A, B, C, and para 24. ये यहाँ से 22, 23, and 24. तीनों import करते हैं. And para 24 has already been complied with. The arrears of salary as per the direction of the learned single judge has already been paid to the petitioner, and the cost of rupees 30,000 has also been paid to the petitioner by the respondent number 3. Full stop. It is also submitted that pursuant to the liberty granted by this court in para number D, the private respondent has already prepared a suit before the concerned civil court, and the same is pending consideration. Full stop. In view of the fact that the directions issued by the learned single judge has already been complied with, that also before filing of this writ appeal.
Some I think during the pendency. Your lordship will simply say that it has already been complied.
Has already been complied with. We are not inclined to interfere in the impugned order passed by the learned single judge. However, it is open for the appellants to oppose the claim of the petitioner, the private respondent for salary from 1/1/2015 to 31/7/2019 raised through a civil suit before the concerned civil court. Always open for agitate the claim of the court in accordance with law. With these observations, this writ appeal is disposed of pending IA, if any, is also disposed.
Right.
For admission, item 12 and 13.
He was supposed to file a reply.
ये कौन सा था?
Oh, in one case.
No,
Item.
yeah,
So you're supposed to file in counter
Malad, we have filed,
when?
Malad, on 9/4/25, Malad, in WPC 5624/24, item 13, Malad. And they took time to file a rejoinder to our affidavit on last day. Kindly take up order dated 21/4/25.
In this one, and what about the another?
Well, the issue is same, Malad.
Issue
Same,
is same.
same petitioner, same issue.
So would you like to file any count?
That is legal question that they have raised.
No, if
Doesn't-
you are in requirement of filing any that and otherwise not, then it's okay.
Not required.
Hmm?
Not needed.
Not required. Okay. Counter to the writ petition, though counter to the writ petition number 5626/2024 has not been filed by the state. However, the counter in the writ petition number 5624/2024 is already filed. Learned Counsel Mr. Deenath has submitted that the counter filed on behalf of the state, that counter filed on behalf of the state in writ petition number 5624 of 2024 is sufficient, and therefore there is no requirement to file counter to the writ petition number 5626 of 2024. Learned Counsel appearing for the petitioner has submitted that there is no he'll not file any counter to the affidavit in opposition filed on behalf of the respondent number 1 in writ petition number 5624 of 2024. Full stop. That is you're challenging this
The validity of Assam Land Acquisition and Requisition Act.
Requisition Act. Having heard the learned counsel of the parties, we are of the view the matter required consideration, hence admit no need to issue notice as parties are already represented. List this petition for hearing in due course.
But
My lord, there is urgency, my lord.
You'll move an application, then we'll consider. Yes.
Item 17 and 18.
Chaudhary, what about that?
In one case,
Sir, what about the sanction of Anganwadi centers?
that is what Lordship, if I may take your Lordship to the letter my friend in the state government has pressed before your Lordship. Your Lordship will come to the letter dated 4th December. It was on the basis of this letter that he had submitted that it was being forwarded to the state central government. Your Lordship will kindly see. This is their interdepartmental letter.
Page.
This was given just, it was not by way of an affidavit. It was not by way of an affidavit. A letter dated 4th December 24.
I did not serve this copy.
No, he made a submission based on this letter. I have got a if you're
Sent on 26/11/2024.
That is what Lordship will see. This is a communication dated 4th December sent to the learned council.
No,
Lordship is coming.
Sharma,
Lordship is reading the last
state
paragraph.
government has already requested the sanctioning itna.
There
It is submitted, the said request was sent to the central government on 26/11/2024.
Lordship will read. The director has sent a letter to the state government, not to the central government. Lordship will kindly read with me.
Where is that? Read from where?
I'm reading the letter.
You are reading the letter. We don't have the copy of that letter.
Lordship, he has placed the letter.
Here, this file is here.
I have obtained a copy from my learned friend. It is the director has written a letter to the secretary to the government of Assam.
Mr. Sharma, where is that this letter of 26/11/2024? Earlier occasion, where is now? You must have a copy of that.
Lordship,
So you don't have any other copy with you. Sir, we want this 26/11/2024 order, letter.
26/11/2024, the director
There
has
is a copy of that. Let us verify what you are saying.
yes. I have a copy.
So then submit a photocopy.
I have a copy. A letter was written by the director to the secretary of the state.
Not filed the affidavit. He has not filed the affidavit.
Secretary cases, Mr.
বুঝতে পারছি আপনার যেহেতু তো ফাইল করা নাই না আপনি ফাইল করে দিন আপনি ফাইল করে
That was the to my the state government has sent it to the central government. Not sent. That the director has written to the secretary.
We are asking for this letter dated 26/11/2024, and you are referring to September 2024.
Lordship. Lordship will read the last paragraph of the letter written to my learned friend.
This also speaks about 26/11/2024 order.
Lordship.
Last two lines of this 4/12/2024.
Yes, Lordship. In view of the above, a proposal has been submitted to the government of Assam, Department of Women and Child Development Dispute for consideration of establishment of 3 numbers of AWC in the uncovered areas, that is Rangajan number 3 line and Jungle line, Rangajan number 5 number line and Kodikotia so and so. Why? This office letter number so and so, this office letter is this director has written.
Read next.
Yes. This office letter number so and so dated 26/11/24. So the director has written to the secretary to the government of Assam. Whether the secretary has forwarded any proposal.
Okay. Mr. R.K.T. Chaudhary has submitted that the central government is not in receipt of any recommendation of the state government for sanctioning 3 new Anganwadi centers at Rongaja, Kharikotia revenue villages, namely Rongazan number 3 line, Jungle line, Rongajan 5 number line, and Kharikota 10 number ward. Full stop. Mr. D.K. Sharma, learned counsel for the government of Assam, shall file an affidavit of this effect that the recommendations have already been, the recommendations for above referred 3 new Anganwadi centers have already been sent to the central government by the next date of hearing.
Lordship, with regard to next item 18, no affidavit has been received as yet
By whom?
by the state respondent, Lordship.
File your affidavit, Mr. The respondents are also, respondent state is also directed to file an affidavit in PIL number 72/2024 by the next date of hearing. Just after 10 days, 2 weeks.
Item 19 and 20.
Deeply obliged.
May I please? Well, in terms of your lordship order in last.
Present.
Sorry, Vinod. That's fine. appellant number
In
six.
respect of this Sonitpur district, the petitioners are in receipt of some dues or what?
Four appellant, that is 6, 7, 8, and 9. They are paid.
They have
6, 7, 8, and 9 of the item number 19. They are paid.
they have
Paid. They
been paid.
they have been.
And what about the others? Others,
Other
they are
matter,
saying that
they-
it is under
for-
process.
It is under process.
In respect of others also, the proposal was sent, my lord, but sanction was not received. So that is.
And in respect of item 20, my lord, notice has not been issued. So that in item 20, notice may be issued.
It belongs to which district?
District wise, we have not here awarded, my lord. By the same judgment. Altogether in the 274 are there.
So that considering for giving all of them,
Yes, there.
otherwise in this challenge to the writ appeal, there is no force.
No.
Yes.
There is no force.
Yes, my lord.
Simply out of it, the state government is giving on its own, it's okay. Okay, learned council appearing for the state has submitted that. The appellants in writ appeal number 297 of the, that out of 15 number of appellants in writ appeal number 297 of the 2024. 4 has already been paid the arrears of salary belonging to the Sonitpur district. However, in respect of districts of Jorhat, Nagaon, Shivsagar, and Tinsukia, the matter is under consideration and it is expected that their arrears of salary will be cleared in the current financial year 2025-26. In respect of the petitioners, appellants of writ appeal number
71. 71 and 25.
71 of the 2025, the council for the state has submitted that he is not, you are in receipt of that copy?
No, my lord.
He is not in receipt of the copy of the writ appeal. Learned counsel for the petitioners are directed to supply, appellants are directed to supply the copy of the petition to the council for the state during the course of the day. Just after 3 weeks.
Ma'am.
इनका भी आप just make it sure in the other appellants may also get.
Yes, all right, man.
71 are public property.
Item 21.
Maybe.
Yes, Mr.
Yes.
You have filed the affidavit.
I have received the instructions and after going through the instructions and the affidavit already filed in the writ petition, my respectful submission is already stand is there in the affidavit. I can bring it to your lord.
There is no requirement of any filing in affidavit.
Already the stand is clear. Yes, kindly take up the order dated 6/3/25. That was the query of the honorable court on 6/3/25.
Yes, 6.
6/3/25 passed in the writ appeal. That was the query. Honorable court has said on it.
On a query based on notification dated to the effect that the promotions remain to be compared to the respective, how the advertisement impute in connection with the respective sustainable.
Yeah.
If they granted weeks time, what is this? 9 and 10?
9 and 10 kindly come to page number 45.
Page number
45 of the GTP. This is the notification, clause number 9 and 10 is here.
9 and 10.
9 and 10.
Yes.
9, the promotion shall be confined to the Anganwadi centers of the same revenue village, and as such, an Anganwadi helper of one revenue village or ward of a municipality or town committee cannot apply for promotion in the post that arises in the center falling in a different revenue village or ward of a municipality or town committee. Then second 10 says it shall be the responsibility of the CDPO to determine the vacancies and advertise them, calling for application from the eligible Anganwadi helper with prior permission of the Director of Social Welfare Assam.
Is the promotion to the post of superintendent?
No, this is between Anganwadi helper and worker.
Anganwadi helper to
worker.
Worker.
This is a guideline by the state of Assam, which provides an opportunity to the Anganwadi helper to get promotion. In fact, it is an upgradation to the Anganwadi worker. If the post falls vacant, the central government, here one situation kindly take note of. The petitioners are they are not Anganwadi helper. They are intending for a direct recruitment. They are fresh candidates.
Okay.
They are fresh candidates. They want to participate in for the Anganwadi worker post. But what happened in a Anganwadi center? There is one Anganwadi worker and one Anganwadi helper. Now, this central government has issued a letter in 2006. That letter they are harping. In that letter, Government of India has said that that 25% of the post of Anganwadi worker should be kept for Anganwadi in-service Anganwadi helpers. In person to that, 4th of March 2013, this notification has been issued by the Government of Assam. There, providing an opportunity for the Anganwadi in-service Anganwadi helper who has completed 10 years of service. At the starting of the Anganwadi center, suppose in this particular ICDS project, we have 400 Anganwadi centers. We have 400 Anganwadi worker and 400 Anganwadi helper. In between, if for any reason or superannuation, death or resignation, some Anganwadi post of worker fell vacant, then only the Anganwadi helper will get the opportunity for their upgradation or promotion. So in that case, the first condition is that the Anganwadi helper or worker has to be from the same survey area of the Anganwadi center. But in this, we have relaxed to that some extent, so that in the revenue village has been considered. In one revenue village, there may be 2, 3, or 4 Anganwadi centers. So the 4 Anganwadi helpers within that revenue circle, within that revenue village, will get the opportunity to contest to participate for the Anganwadi post, if Anganwadi worker post, if some fall vacant. So in that way, the 25% we have to 25% out of total 400 we have to consider. So that was the stand. We have clarified that in the affidavit filed by the secretary, departmental secretary in the writ petition, and that was considered by the honorable court. Now the case of the petitioner is that the advertisement was issued entire post were for the promotion of the Anganwadi helpers. Well, we have given the calculation that out of 400, 25% we have to calculate
From the
helpers. It is 100. And as on today, only 21 helpers we are in a position to accommodate, because we don't know which Anganwadi worker post is going to fill up, going to be vacant. Some may die, some may resign, or some may retire. Retirement, of course we know, but in case of eventuality, death or resignation, that is not known to us. So therefore, 25% we cannot fix the 25% roster that these are the posts we will fill up by promotion. So in that situation, whenever Anganwadi worker post becomes vacant, then the clause 10 has given the power to the CDPO concerned that you identify the post that this has fallen vacant, take the permission of the director, and accordingly director will approve and he will issue the advertisement, giving an opportunity to the Anganwadi helpers within the revenue circle wherein that particular post will fall. Kindly come to the affidavit of the secretary, departmental secretary, filing the writ petition. That is at page 48. We said, my lord, 49.
Just but their basic case is that these posts, with 17 and 20 posts which you have advertised for filling up by a promotion, it is more than the 25% of quota.
That is their allegation. They said that when the vacancy is 20, we should have advertised 25% of 20, not the entire post for promotion.
Vacancies of 20.
That is their case, my lord. If logically takes up, the writ petition is available at page number 25, my lord. The paragraph starts from 25.
Yes.
Paragraph number 2, the writ petitioner says that the petitioner begs to state that she has passed HS eligible for a post of Anganwadi worker in direct recruitment, and as per office order number so and so issued by the office of the CTPO Gauripur ICDS, there exists vacancy of 20 numbers of Anganwadi worker under the Gauripur ICDS project. They said that on 8/7/2022, the CDPO Gauripur ICDS project issued an impugn advertisement whereby invited application from the helper who have completed 10 years for filling up vacancies of 12 out of 20 posts by way of promotion, and another advertisement issued on so and so for filling up the post of another 5 posts by way of promotion. So these two advertisements they challenge on the ground that
No, this now come to this Gauripur ICDS project.
logic.
So total in Gauripur ICDS project, how many posts are?
Kindly come to page number 50. This is the affidavit.
How many posts are there?
400 total. 400
Total 400 posts of Anganwadi workers.
Anganwadi centers. So one Anganwadi center has one Anganwadi worker and
Total
one
400.
400.
And you are saying this 400 posts out of this 20% of the 25% of the quota, you are filling only of that quota.
Yes.
Not those others, the left out quota of 75%.
Well, all in fact, all centers are filled up. These some posts sometimes get vacant because of resignation or because of death or because of superannuation has not come yet. Well, so far in respect of out of 100, 25% is 100. Only we could fill up 21 posts. So 79 still remains. So whenever vacancies arose, if suppose well, kindly
suppose if 10 vacancies of Anganwadi worker is there, then you have to fill 25% out of from promotion and 75% from direct recruitment.
well, already posts are filled up. So kindly
Already posts are filled up. Whenever you are filling the post, then out of those posts you have to fill this 25% from the workers by way of promotion, and otherwise you have to recruit them by direct recruitment.
But if we we have to maintain the 75% and 25%. That is why kindly come to paragraph 3 of our affidavit at page 50. We have said, suppose a post is fallen vacant today, that has to be then the Anganwadi, the particular helper of that center, because the helper cannot go outside the revenue.
At present, you are saying only 20% posts are vacant here.
In
this Gauripur ICDS project, how many posts? 400 posts are there.
Total 400. Total
400.
center 400.
And now at present, 20% posts are vacant, or 25. How many posts? 20 posts are vacant.
25 comes to 100. At that stage, they have advertised 17, 12 and 5, 17. Because those posts, because of some reason, death or something.
17 you have advertised.
We have advertised.
By way of promotion, to filling the post by way of promotion.
Yes.
Then you have to at least show that out of these, all the filling posts, these are the direct recruits and these are the promotees. Where is that bifurcation?
Well, kindly.
Then only we will came to know that yes, now you are filling the promotional quota only because direct recruit quota is already there.
Already there. Kindly
show us.
That is
that chart.
That is why para 3 I have indicated.
Para 3.
Para 3 page number. This is relevant. Page number 50.
50.
50. That so for the subject matter of the instant writ petition, a report dated 6/1/24 has been received from the CDPO Gauripur ICDS project, indicating that Gauripur ICDS project comprises 400 Anganwadi centers. Accordingly, 100 positions of Anganwadi worker, that is 25% of the 400, are to be considered for upgradation, promotion from amongst the Anganwadi helpers as per criteria laid down by the notification dated 4/3/2013 issued by the government of Assam. The report further states that in Gauripur ICDS project, 21 numbers of Anganwadi helpers have been promoted, upgraded to the Anganwadi workers. This implies that in Gauripur ICDS project, a further 79 Anganwadi helpers can be considered for promotion, upgradation to the post of Anganwadi workers under the project.
You know, for that you have to give that these out of 400 posts, these are the appointed, these are the persons who are recruited, directly recruited.
Yes.
And these are the persons, the Anganwadi helpers to whom the promotion was granted on or selected for the post of Anganwadi worker. So if there is some gap in that, then only you can fill those posts by way of promotion. Otherwise, you can't.
Well, as on that day, we cannot, right at this moment, we cannot keep a particular post reserved that this worker post will be filled up as by promotion.
Then what mechanism? What mechanism in for that purpose?
Kindly consider. We have to go by the total figure only. Because which Anganwadi center is going to be vacant tomorrow, we don't know.
That's something you are right. Okay.
So that is why whether the petitioner has to be from the local resident of that particular Anganwadi center only. So we don't know whether the A center will be vacant tomorrow or B center will be vacant tomorrow.
But then how do you adjudicate that this is for the by way of promotion quota and this is by way of direct recruitment?
But we go by the figure. As on that day, only we found that 21 have been already upgraded. So the 25%, that is 100, still 79 at that point of time.
That I think so it is not sufficient.
But
you have to give us a chart that out of these 400 posts, these posts are already filled by the direct recruitees, and therefore now the remaining posts are to be filled by the promotion.
At the
you give us the chart.
We'll give.
Clarify this position. Otherwise, it's at your whim.
No,
whenever any post is, you will say, okay, we'll fill it by promotion.
Yes.
That
as on, I'll give the chart. I'll give the chart, but as on today,
okay,
I'll give it.
Learned concept of the opponent state has submitted that. So this court on 25/4/2025 has issued direction to the Director Social Welfare of Assam to attend the office of the Senior Government Advocate with the relevant instructions. But he feels that there is no requirement for seeking further instructions from the Director of Social Welfare of Assam, because the position is clarified by way of affidavit in opposition filed on behalf of the state. Full stop. Be that as it may, having heard the learned counsel of the parties, we are of the view that the state government, that the respondents are required to file an additional affidavit detailing out that out of the 400 posts of Anganwadi worker in Gauripur ICDS project, how many posts are occupied by the direct recruitees and the promotees from the and the persons who have been promoted to the post of Anganwadi worker from the post of Anganwadi helper. Full stop. Because the learned counsel for the respondent has submitted that the 75% quota of the Anganwadi workers, which is required to be filled up through direct recruitment, is already saturated. Full stop. Learned counsel for the respondent may file affidavit of this effect, detailing out the position of filling of vacancies by direct recruitees and promotees by the next date of year. Put them on.
Give it 2 weeks time.
Fix a date, Lord.
Date is in a list after 2 weeks, a particular date.
Yes. Fix date. I'm hello.
Item 23.
Lordship, in this case, notice was issued and the Lordship was pleased to stay the impugn order also. And last occasion, my friend took time to file counter, Lordship.
Actually, my lord, we seek getting. That is the difficulty.
Just yes.
Actually, my lord, we have already prepared the affidavit, but actually that person is very sick, my lord. That is the difficulty. And
How much time?
Lord, 2 weeks at least, my lord.
Learned counsel filling for the respondent. Full respondent.
So rest.
Sole respondent.
Full respondent raised some more time to file affidavit in opposition because the whole respondent is under medical emergency. Just after 3 weeks.
Lord,
Item 25 and 26.
Lordship, in item number 25, I have filed affidavit in opposition
25.
for respondent number 6.
I have received my
Yesterday,
yesterday
Lordship,
record.
that may not be on record.
Yesterday तो कहाँ से आएगा? You filed only yesterday. तो कैसे
Yesterday.
Because I received on yesterday, well,
Would you like to file then down?
but I'm not fine.
ठीक है. Learned counsel appearing for the respondent number 6. Still these petitions are some issue is surviving here.
My lord, yes, my lord, because on the day so far, my lord, utilization of the e-stamp is I have not matter, my lord. We think is that my lord, the non-utilization of the physical stamp and the my lord, because of that reason, my lord, all the members of the association they are suffered and how they are suffered. That is still my lord considering here. But only that aspect, my lord, because the huge amount, more than 300 crores rupees are lying, my lord, in the exchequer. Because of this untimely decision.
All is now online. The
But that
unutilized
will-
sums can be allowed to
But
be.
that to be looked into, my lord, because the 300, it is not a matter of the job, but 300, more than 300 crores of this.
Learned counsel appearing for the respondent number 5 in respondent number 6 in PIL petition number 17 topic 2023 has submitted that he has filed an affidavit in opposition only yesterday. So the same is not available on record. Registry is directed to place the same on record and list these certain matters after 3 weeks.
Item 27.
Lordship, I have filed in WBC, Lordship, not in PIL.
Okay, WBC.
Master best.
Your Lordship, on the
Guarantee certificate or
guaranteed.
agreement.
I have bring it, Your Lordship. If allowed one day time, I can bring it on record by way of an additional affidavit.
Also show it to him.
Lordship, actually, this, we are already accepted that we were in 2006. So this is the guarantee which was in 2006 only.
But what it says, the clause which you are relying on.
Yes, your lord. Your lordship, page number 3, page number 2, para number 1, 2, 3.
Three.
Your lordship, it is not in dispute that the guarantee is a continuing guarantee. And at the page number 3.
Just show us, na?
Yes. Your lordship, para number 1.
Yeah.
At page number 2.
Yeah.
That is, para 1 is written in Hindi and below that it is in English, your lordship. My and our liability under the present is a continuing one for all sums whatsoever which may at any time be or become payable by the customer to the bank on any account whatsoever with interest, and all cost and charges and expenses and shall remain in force
Until
3 calendar months after we shall have given or sent to the bank notice in writing of my intention to discontinue and determine these presents, and shall have paid to the bank all money up to the limit of my liability at the expiration of such notice. And in the event of my or any of us dying or being under the legal disability, the liability of the survivor or the survivors of us and the estate and the executors, administrators or legal representative of the deceased guarantor shall continue until the expiry of the 3 calendar months. So till date, they have not given their any notice for discontinuation.
suppose if they give you a notice.
I'm coming to that.
Then?
Yes, if they will give, then they have to pay the entire amount to us first.
The entire amount which they have guaranteed, that they will pay.
Yes, your lord.
Entire amount, which entire amount? Of 70 lakhs?
Yes, your lord.
I was only for 2,08,000 and
No, not 2,08,000. Your lordship, then again, your lordship, in para number 2.
Yeah.
I hereby consent to the bank making any variance that the bank may think fit in terms of the account of the customer with the bank, and to the bank determining, enlarging or varying any credit to the customer, and to the bank making any composition with him or promising to give him time or not to sue him, and bank parting with any security it may hold for the guaranteed debts. And then your lordship, para number 3. I agree with the bank will have a full discretionary power with any further consent or without in any way affecting my liability under the guarantee to renew or vary the terms of the overdraft or case credit account or demand loan or term loan account or other account, or to renew the facility regarding opening of letter of credit from time to time, or negotiate fresh bills or issue fresh guarantee on behalf of the customers and obtain fresh documents or in renewal of the documents now taken or to be taken or part with the security received or to be received from the customer, and that I shall not be discharged from my liability by any such act on the part of the bank or by the bank obtaining renewal document or fresh document from the customer or by extension of the period of help. Your Lordship, he cannot be discharged until the bank discharged him or by the operations of the law.
Now, my lordship,
Page number 2, your lordship, one more small submission. Page number 2, he hereby undertakes, it is specific. I hereby undertakes on demand to pay and discharge all present and future indebtedness liability. It is not confined to the language of the NSC that has been FDR placed before the bank. That is at page number 2, line number, your lordship, after handwritten, it starts from hereby. So it is not a limited liability guarantee, only to the extent of 2,08,000 or 5 lakhs or 10 lakhs, whatever.
lordship, in this thing, the continuing guarantee which my learned friend has been following in the Indian Contract Act, the continuing guarantee, there are provision of revocations also. One is that by writing to the creditor and he being accepting it. There are other sections too, which in fact does not happen. If that doesn't happen, it is in Indian Contract Act. There are two such one sections. Section 62 is there. Section 62, may I please read your 62 is effect of novation, decision and alteration of a contract. Now what happened is actually since the 2008, since I have not been the, my name has not been in the guarantors list and some third party has came down, the contract has changed. That the contract has been enhanced.
Your lordship, it is enhanced. It is not changed. It cannot be taken in line with the.
Just a minute, let him complete.
Here it is said that if the parties to a contract agree to substitute a new contract for it or to rescind or alter it, the original contract need not to be performed. And here the illustration is actually the one which we are.
But kindly get this page number 3. This guarantee agreement.
Yes, Lord.
I agree that the bank will have full discretion without further consent from me, without in any way affecting my liability under the guarantee to renew or vary the terms of the overdraft of cash treasury account or demand loan or term loan account or accounts or renew the facility regarding opening of the letter of credit from time to time, negotiating fresh bills or issue fresh guarantees on behalf of the customer and fresh documents in renewed documents now be taken the part of the security deposit. What is this?
This agreement cannot be,
You're given everything here. You can change it. You can do whatever you want. But my liability will remain. Would remain.
Lordship, here actually what happening is that there is one certain limitation period for some documentation. In fact, the bank has always, they have already approached the DRT without me only. Without me.
Sir, that will not relinquish your this liability. As per what is the impact of it? Look into it, sir. Otherwise, the face of it, prima facie, it appears that as per this guarantee agreement.
This guarantee agreement was, it is written as something as until 3 months after I shall.
What is the effect of that? That is in respect of notice.
Yes.
So whether you have given any notice or they accepted it.
Lordship, in the contracts, I have not given any notice, but there are two sections which say.
Sir, if you want to submit on this, then it's okay. Otherwise, the TK will pass an order.
I would like to actually. I could like to. Then give us a short date.
You place it on record.
Yes, I will bring it on by way of an additional.
Relying on these provisions on the basis of which this guarantee is treated to be as continued here.
Yes, your lord.
Let us pass it up for the respondent. Directed to 5. What this document exactly says?
Guaranteed deed, your lord.
The guarantee deed executed between
guarantee agreement.
The directed to place the guarantee agreement executed between the respondent by the petitioner and the respondent bank, highlighting that which provision of the guarantee agreement deemed which provision of the guarantee agreement stipulates that the guarantee given by the petitioner would be a continuing guarantee. Full stop. The affidavit be filed within a period of
Your lordship, by 3 days, your lordship, by Wednesday.
within a period of 1 week, while while supplying the advance copy to the counsel for the petitioner, the counsel for the petitioner may file rejoined may file response to the said affidavit if desired so
I will.
within a period of next week, this after 2 weeks.